Hey, I'm Rodney Rouzan. Just here to document today of what's been going on with my case with the Los Angeles Civil Service Commission. It's my appeal from my termination after 24 years of employment as a police officer with the Los Angeles Airport Police Department. So I'm currently about 6 days into the hearings, and I haven't posted in a while. Now, let me explain to you why I haven't posted in a while. On July 12th, we had an open hearing, open to the public, and it was on Zoom. When that hearing started, approximately 20 people were on the call, and immediately the city attorney started with, they wanted a roll call of everyone that was on the call to identify themselves. After they had everybody identify themselves, then the Civil Service Commission um, moves us to a breakout room. So what you have is the Civil Service Commission, who's like the entity running the hearing, and then the Los Angeles World Airports is like the one prosecuting the case, and then I'm like the defendant per se, like in a court hearing. So both of us are in there. So they're the ones bringing the case. I'm the appellant appealing the case. So that's how this process takes place. So the first thing that the city wants to do is they want to break away from the public, and then they want to take us to what they call a Zoom breakout room. Now, I'm in this breakout room. There's two deputy city attorneys from the Los Angeles World Airports. Then they have a representative there from Human Resources. Then they had the hearing officer comes to the back, as well as the court reporter. Then immediately they start bringing the deputy city attorney brings what she calls an oral motion, and they bring an oral motion, and then they make the claim that they have major concerns based on my YouTube channel. And I've already posted 6 videos, but they had major concerns, and they believe that it could be witness intimidation. And they're just saying this. I didn't have any of the moving paperwork. I was just kind of like, what are they talking about? And due to the fact that they had these concerns, they wanted the hearing shut down to the public. They didn't want to even let me do it remotely any longer. They wanted me to have to come to City Hall each time. They wanted to make sure there was no recordings, and just to these extreme measures. Well, one of the first issues that I had is, one, they're accusing me of witness intimidation, and two, they're trying to bring a motion. Okay, so let's go over first. They're bringing what they call an oral motion, which I don't even believe there's a provision for it. And here's what a motion is. Typically speaking, you have a notice of motion and the motion, and then that directs the hearing officer to do something. It's a request from you. So the notice of motion informs all parties involved about the upcoming motion hearing. It should contain a caption and a title. Okay, that includes the court names, the parties involved, the case number at the top of the document, etc. Okay, then the hearing details. It should give a date, time, and location of the hearing. Okay, then the relief sought. It should clearly state the specific order or action you are requesting from the hearing officer. And then it will state also the grounds for the motion. It will briefly outline the legal basis for the motion, referencing relevant statutes and rules. And then service information. Okay, so then there will be proof of service on it saying that it's been served to the other opposing side. Now, that's the notice of motion. Now, there's an actual motion that also needs to be included. And what the motion is, it's a formal request, okay, to a court to grant the relief sought. It should include an introduction. It should restate the relief you are seeking. It should provide a brief overview of why the motion should be granted. Statement of facts. This should present a clear and concise account of the relevant facts supporting the motion. Should be legal argument in there. This should detail the legal reasoning behind your request, cite the pertinent statutes, case law, or rules that support your position. A conclusion. Summarize your request and reiterate why the court should grant the motion. And then a signature. And then also it needs supporting documents. And the supporting documents are memorandums of points and authorities. Okay. And then declarations or affidavits. If they're saying there's witness intimidation, Where's the declaration or affidavit from the party that's saying they've been intimidated? Okay. All of this would need to be put forward with their motions. Okay, so it would be a notice of motion, then the motion, and that's what's required to put forward in order to have it even heard by the hearing officer. Now, the standing rule at that time, the hearing officer told I would always have 3 days to respond to any motion. Well, on this day, they're bringing it orally, it's not in writing, and they're now that she makes a decision on it on that day. So I found that to be very interesting. So when they start talking about this motion, they tell the hearing officer, we just want you to watch the videos and we want you to make a determination if you believe that it could be witness intimidation. Okay. Now, I really want to go specifically into what witness intimidation is. Witness intimidation is defined under California Penal Code 136.1. To convict someone of witness intimidation in California, the prosecution must prove the following elements. Okay. Knowledge and intent that the defendant knowingly and maliciously prevented or dissuaded or attempted to prevent or dissuade a victim or witness from doing any of the following: attending or giving testimony at any trial, proceeding, or inquiry authorized by law; reporting a crime or violation to law enforcement officers, prosecutors, judges, or other appropriate authorities; assisting in the prosecution of a crime; or finally, aiding in the arrest process of any person in connection with the crime. Now, nothing on any of my YouTube channel fits any of these elements right here. So for them to accuse me of witness intimidation and they have no affidavits and they have no moving paperwork is pretty egregious to me. But that's what happened in this situation. So then what the hearing officer does, at this point in time, we were probably even 10:30 or 11, and she says she's going to look at the YouTube videos and then she would make a decision on it. So over the lunch break, she takes a look at these YouTube videos, and she comes back after the lunch break, and it was either 12 or 1 o'clock. I don't recall the exact time that we come back from the lunch break. Reviews the videos, and she gives the following ruling. She says, due to my opinion, after reviewing the materials on Mr. Rouzan's YouTube channel, that the witnesses could reasonably be intimidated by the content on Mr. Rouzan's social media and YouTube channel, and inasmuch as a prohibition on the recording cannot effectively be implemented for observers in a virtual environment. Mr. Rouzan, number one, and she only gave me these two options. So I don't no longer have a right to an open recording or anything else, but she gives me these two options now. She says, I may preserve my right to an open hearing by opting for an open in-person hearing with no recording permitted. Or number two, he may preserve his rights to closed captioning of the proceeding and no expense in traveling with a closed virtual hearing during which he is ordered not to record the proceedings. So in both instances, they no longer wanted any form of recording. So then they come in here and accuse of witness intimidation with no moving paperwork, no facts, no evidence, and then not even no due process, not even an appropriate time to respond, which the standing rule at the time was 3 days. They don't even give you that time to respond, and then they take away your right to this public hearing and also that I record the proceedings. And so I find that pretty egregious. That's what happened in this situation, and I'm just documenting that at this time. So there'll be more to come, and I find that pretty curious. Think to you, and it's my public hearing, and I have the right to a public hearing, and it's my right. But they're the ones that seem to be wanting to have it closed for their privacy, which doesn't make a lot of sense.
Words in papers, words in books, words on TV, words for books, words of comfort, words of ease, words to make the fighting cease. Eat your words, but don't go hungry. Words have always nearly hung me. Words are stupid, words are fun. Words can put you on the run. Concrete words, abstract words, words to tell you what to do. Words can put you on the run.